Originally we thought we were not going to field questions and answers. We didn't know what the turnout would be, but I guess we could sneak a few questions in at the tail end. Okay, terrific, okay. As long as we are out of here by 8 o'clock tonight, that should work. Okay. So, because there are a lot of new faces here this evening, I wanted to really talk a little bit about what is the Condo Rights Workshop and what's the series and what it's all about. So this program has actually evolved over the last year. It started with an inquiry through our city newspaper where we said, I'll have hours, clinic hours. We'll establish a condo clinic where people can come in and talk to me on a one-on-one basis, and that was really the starting place for that. And I met actually with one of my constituents in the city of Sunny Isles Beach, and she said, I thought this was going to be a group activity, so or I thought we were going to take classes or something like that. And I said, you know what, we could try that out, and that's what happened. So I started the Condo Rights Clinic. A couple of meetings in City Hall in the commission meeting room, and then sort of spread out a little bit went into North Miami Beach, and really wanted to mix it up and try different themes. It was originally conceived as what is 101? What's a declaration of condominium? What are rules and regulations, and just very, very basic stuff. And now it's evolved into more interesting or topical issues. And certainly this issue about First Amendment rights is really a great cutting edge issue, something that affects a lot of people in this room, which we're going to get into. So that's what it's about. And the perspective is that probably most people in this room, can you raise your hands, who's a unit owner? How many people in this room are unit owners? How many people in this room are board members? Okay. So, as you know, as a unit owner, and that's the vast majority, they don't have access to attorneys. So we have these great association attorneys like my friend and colleague Michael Gongora, but who do they report to or who do they communicate directly with? They don't really communicate. That's correct. They don't communicate with the unit owners, they communicate with the board. So, and typically, primarily the president. So the idea behind the Condo Rights Clinic or workshop was we have to get information out and have a direct dialogue with the unit owners because they just don't have access to legal counsel, access to, inform people about condo rights and so forth. So it was really about what are my rights, and that's primarily as a unit owner. And actually the topic of today, the impetus for this topic was really, I was contacted by a local reporter on the idea that in Key Biscayne, a unit owner tried to publish a board meeting on YouTube, and the association attorney came down very hard on that unit owner and said, you do not have a right to republish a board meeting on YouTube. So that reporter contacted me. His name is Tony Whitten. I was hoping he was going to be here tonight, but I don't see him in the audience. And I wanted to acknowledge him because he really started that whole conversation of what are the rights? The rights to publish, the rights to speak, the rights to assemble. And that was really the starting place for this particular discussion and this conversation. So now I want to introduce our esteemed panelists for this evening.
All right, thank you, Dana. I'm Michael Gongora. I work with Becker Lawyers, and I'm kind of making my debut tonight at one of Dana's Condo Rights Workshop, although I do speak frequently on the topic in many places. I've been working as an attorney for 25 years, the past 15 pretty exclusively in condominium and HOA law, and I had the pleasure recently, a couple of years ago, when the Florida Bar created a board certification in condominium and plan development law to be one of the first people included in that group. Fortunately, without taking the test. I was old enough because I don't know if I would have passed. It looked very hard. Apart from that, I do live in a condominium. I have served on a condominium board in the past, although I do not now. I represent the city of Miami Beach on the commission, so I'm kind of on a giant condo board, if you want to look at government that way. So I deal with more than my fair share of meetings. I'm excited to talk about this topic by discussing what the law is, some real life situations. I'm not going to give any specific legal advice from up here, because I know there's some people that are on boards of Becker clients, some people that are not, that are litigating against their boards, so I don't want to get wrapped up in any type of ethical dilemma. But as Dana stated, I will be here after the meeting and will be pleased to take your individual questions. Thank you for coming out tonight to hear us.
Hi everybody, my name is Dan Barsky. I'm a partner at Schutz & Bowen and adjunct professor at the University of Miami, actually School of Law and some other schools there. Unlike the two panelists to my right or left, I am not a condo lawyer. I am an intellectual property attorney. And I deal a lot with down here where things cross over into the realm of condos, buildings, name rights, etc. It comes up with renting out units, Airbnb, on-site property management, etc. I am a resident of Miami Beach, so this is my commissioner over here. Actually, first time we met was when he came to my house looking for votes, and I thought, oh, okay.
I go door to door every election.
So I am here. I've tried multiple defamation cases, including the political realm. So I've got experience in dealing with those issues, and you will be talking about some of those coming up. But I get into a lot of the what can you say, what can't you say, where are those rights, and how does that all work? Because it's I think it's a lot more complicated than most people realize. Just like the commissioner, I am not giving any specific legal advice to anybody. Like I say with my students, I will answer hypothetical questions to the extent that I can tell that they're not directly related to something that you're involved in. Again, I work for a large firm, and I don't know where, who's with who, what's with what, and so, obviously avoiding any type of ethical issues. Anything that I say up here is not legal advice, but you need to consult an attorney.
Terrific.
It's not one of us.
So,
Or it is one of us, but outside of this realm.
So as most people know, I do serve a couple of roles in life, and one is in public office, but also Dan is a partner in my law firm, and so that's how Dan came to the table. So we're really, really excited to have him here because, again, First Amendment rights, these issues are really, I think, very cutting edge, very topical right now. It's a little bit of and especially social media, it's a little bit of the wild, wild west, right? Okay, especially for condominium unit owners. Okay, so, first question. Okay. Does the First Amendment apply to condominiums? So here's just what the First Amendment says for those of you who've been out of grade school for a while. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech or of the press or of the right of the people peaceably to assemble and to petition the government for a redress of grievances. So does that apply to condominium owners or to condominium dwellers and living?
You want to take this one?
I think like this one's for you.
All right, sure. And the answer is no, right? It starts out with Congress shall. And so this gets into the world of the difference between public and private. And the First Amendment applies to Congress. And as you go through the amendments, the 10th Amendment applies to, says that anything that's not in the Constitution is reserved to the states, and there's some other nuances there, but generally it applies to Congress, federal Congress, right? There's some ways it applies to the state level as well. And when you think about it, it makes sense, right? So I don't know if anybody's seen the movie Coming to America, but there's in the movie, right, there's the McDonald's, then they've got the fake restaurant McDonald's, and what you cannot do, right, you cannot go out and build your own restaurant, call it McDonald's and say, you can't sue me because I have freedom of speech, I can call it whatever I want. That's not how it works, right? Because that is not a law that Congress has made. That is a private business dispute condominium boards, while they may seem, to some to be the omnipresent driving force, they are not Congress, they are not the government, state or federal, and therefore there is no First Amendment issue implicated there.
Okay. So, next one's for you. Is a unit owner's right to speak, publish, assemble derived in the Constitution or by contract?
Okay.
Well, condominiums didn't exist when the Constitution was drafted. Condominiums are a relatively new and emerging area of law, becoming very large in Florida, primarily in the 1970s. So condominiums are created by contract. Essentially, a developer buys a parcel of land, has an attorney draft a declaration of condominium, and record that with the appropriate jurisdictional authorities. And that declaration of condominium becomes a contract. So when you buy into a building, you are bound by those terms. And case law very well establishes that you can sue for breach of a declaration the same as a breach of contract. So your rights as a unit owner all derive therefrom, as well as the articles, the bylaws, the rules and regulations, etc. So as we focus in on tonight's topics, which become more what rights do you have with regard to videotaping or assembling or publishing or speaking, most of that is derived from the contract itself, which is your declaration. The balancing act that we're going to be talking about tonight a bit is how does that play into your First Amendment rights of free speech? And where does somebody's rights to free speech and another person's rights, perhaps, to live peacefully begin? And those are really the areas, an emerging area of law in Florida, which we'll be talking about tonight.
That's exactly right. Okay, so I agree. Next question. What free speech, publication, and assembly rights do associations have?
Okay. Well, the association generally has pretty broad rights. And one of the things that I wanted to talk about a little bit that we gloss over, because there's a lot of people that really come down on, like my friend Norma for 21 years, like my board is bad, my association is bad. But bear in mind that everybody that's serving on the board is an owner. Most condos, I should say that. Some you don't have to be an owner, but the overwhelming majority, you're owners. So it's owner versus owner. You're not talking about owner versus the association like it's some unknown entity. You're talking about a nonprofit board that your neighbors are elected to serve on. So there's a lot of conflict in buildings about who's doing the right thing and who's doing the wrong thing. So let's talk about the association's rights. What can they do? Well, number one, associations have to have meetings. They have to have at least one annual meeting a year. Typically, it's good board policy to do at least monthly or quarterly meetings. So they have to publish that meeting. They have to notice it. They have to have a way of getting that message out. They now, depending on the size of the building, if you're over a certain size, you must have a website where certain records and official records of the association must be there.
How many units? What's the threshold?
What's,
Per
150,
website.
right?
That's right.
150, okay. See, I told you it's a good thing I didn't have to take the test. But yes, it's 150 units or more.
Are you accepting
This-
questions after everybody's questions over, or are you accepting questions during your speech?
You have to, the association has to have,
No.
No,
she's asking,
we're gonna
when-
take questions
when is it gonna be open
afterwards.
to questions?
Right.
We're gonna field questions afterwards.
right.
Afterward.
Typically, associations have this is where I think the question gets a little bit more tricky though. Typically, associations have the ability to send out newsletters and have more direct communication with unit owners, perhaps, than unit owners that are not in favor of what the board is doing or dissenting the board of directors' actions. But right now, I think Dana's specific questions, what can the association do? It can communicate with unit owners. It can send out newsletters. It can email, provided that the unit owners have provided an email to receive those communications. And what it must do is properly notice its meetings, and if you're of a certain size, have a website.
Or a blog post.
What free speech, publication, and assembly rights do unit owners have?
Okay, well, unit owners have the right to assemble. You have the right to attend all the board meetings unless it's one of the rare closed session ones where typically they're attorney-client privilege talking about litigation. But the overwhelming majority of the meetings are open to the public. You have the right to attend. You have the right to speak for a reasonable amount of time on items that are on the agenda. Typically, that's been found to be approximately 3 minutes. You have the right to videotape. You have the right to untape, but it's not an unfettered right. Boards are allowed, the DBPR has specifically come out with opinions, that a board can pass reasonable rules with regard to videotaping. As well, the board can pass reasonable rules with regards to records requests that unit owners make. And the board can also pass reasonable rules with regard to speaking on agenda items. And I think this comes into play because I can tell you the overwhelming majority of my clients, we have no issues. The boards are kind of pretty flexible, they're not big sticklers, and people tend to be very respectful. That's the overwhelming majority. Typically, when you come out to an event like this, it's because you might be in a building where that's not the case. So, in those cases, there are ability to issue rules that limit those abilities.
But not audio. There's no rules for audio, you're allowed to unfettered audio.
Rules for audio.
Yes.
I'm not aware of audio recording rules. Typically, the ones that I've seen are video recording rules. And the most common rules that I've seen passed, depending on the building, because remember, a board is allowed to pass a rule that's not arbitrary and capricious, it's reasonably related to condo management. The ones I've seen are typically, number one, you have to notify the board in advance that you're going to tape. Number two, where the camera is placed, that it either needs to be placed a certain distance back, or you need to be stationary in a seat taping from your phone. A new one, which I'm sure we're going to explore tonight, is what can unit owners do with that video? Are you allowed to pass rules restricting what happens with the video after the fact? One rule that's come up that's been talked about is prohibiting unit owners from then placing that video on YouTube or other third-party sources where non-members of the association would be privy and able to see it. So, these are the emerging issues of law that are coming out.
Okay, now hypothetical. We wanted to invite one of the candidates to the city commission to our rec facility to speak. Is that permissible, or is that showing favorites?
I believe that whatever you do has to be uniform. I think if you're going to permit one person to invite a candidate, then you've opened the door for inviting all unit owners that comply with the rules to invite whatever candidate they might be supporting. I don't think a building has to necessarily open itself up for these types of events if they have specific rules in place. And I haven't seen it as much in political circumstances, but it's come up in religious circumstances.
That was my next.
So here, under 718, no entity, it's 718.123, paren 1, Florida statutes. No entity or entity shall unreasonably restrict any unit owner's right to peaceably assemble or right to invite public officers or candidates for public office to appear and speak in common elements, common areas, and recreational facilities. Okay, so we do have a statutory right to bring in officials and candidates for office, correct? But I think we have to open it up to everybody, right? Not just our favorites, right?
Would that be
I'm a stickler for everything being uniform. In government and in condominiums, if you're going to do one thing for one person, then you need to be uniform across the board. And while we don't typically see challenges in this area, for those of you that have served on condo boards in the past, what is one of the defenses to then trying to enforce your deck or your rules if you're not uniform? Selective enforcement. So you can't selectively enforce which provisions you want to apply, who you want to apply it to. Whatever you do needs to be a uniform policy.
Well, and I would agree. So in intellectual property law, a lot of it is what's called administrative law. That's where the arbitrary and capricious standard comes into play. And certainly, you know, across the board, if you're going to say, okay, well, we'll let person A have somebody in, but person B no, you're starting to get into that question of whether or not that's arbitrary and capricious, whether or not that's improper, you know, favoritism and restricting. So if you're going to open it up, best practice is always you got to treat everybody equal and let them all, you know, do what they're going to do, which obviously then could, in some situations, create problems when you just have a parade of people. So it's, you know, there's a right to, individuals have a right to invite people, and really, if you play favorites, you're playing a dangerous game there.
And before we go on to the next question, assuming we're talking about common area halls or common element halls, it can be restricted on who you can have in your condo. If you want to have a candidate for office or commission or whatever within your unit, you have the right to do so.
But isn't there also a difference between whether it's a board event or if it's an individual happening to, you know, use the rec center for their own invite? Whether it's a unit owner on their own or whether it's a board sanctioned event?
To me, it makes no difference if the board is inviting candidates to speak. Then I think it's open the door for a unit owner to then invite other candidates to speak.
Next hypothetical. We want to use the clubhouse every Saturday morning for religious services. Can the association prohibit us?
There's a case on point. So this is one that we actually have case law to guide us. And there is a case, I don't remember the name, but it's out of Florida, that states that essentially association can prohibit religious services and religious entities from operating in the common elements of the building. And basically in that case, the court kind of weighed, you know, freedom of religion and weighed it with condominiums' rights to regulate what type of commercial practices are happening in the common elements. And in that case, as I recall it, they held that it is reasonable for a condominium to want to regulate what type of practices or services happen. And as long as that prohibition is against all religions, you're not allowing one religion but then allowing another, then it is legal.
What about picketing? Do you have any thoughts on whether a unit owner could picket? Let's say a developer is developing a condominium and a unit owner wanted to picket for some reason. Do you think that would be permissible? Any picketing signs, using picketing signs, picketing, you ever had that experience?
I think there's also a case on this. This is like a legal quiz. Yes, I think the courts held, if I recall correctly, what happened was unit owners sued a developer-controlled association who was doing something that they alleged was bad towards the resales, essentially. And then the developer sued them for picketing and doing things that he said, or who knows, maybe it was a she, whoever the developer was, said was doing that were wrong. And the court, what happened in the court case ultimately was those claims got dismissed as violating the SLAPP provision. You know, you're not allowed to bring SLAPP suits that are intended to basically prohibit free speech rights. And in this particular case, the court held the unit owners that were peacefully picketing and holding signs in front of the developer-controlled association to say that they were doing wrong things, that was protected speech. And that was part of what they're allowed to do. And as such, by the developer suing them for that, it was a SLAPP suit and it was dismissed.
That's absolutely correct. Okay, publications by unit owners. We all know that associations can publish and distribute to unit owners of matters of common interest. What about the unit owners? Is this a one-way street? Can unit owners put flyers on doorsteps or on car windows?
This is for me?
That's for both.
Okay. All right. I personally believe, we're talking about my beliefs, under the law, that the unit owners have the right to communicate with other members of the association. And in particular, this comes up more around election time. You know, as my friend said, I met him at election time because I was walking door to door, knocking on voters' doors, trying to meet them and hopefully earn their support. And I think that unit owners have the right to go around their association, to also disseminate information about themselves, to communicate through means that they believe are reasonable with other owners about issues they believe are happening in the association, provided it's done in a respectful, legal manner that doesn't cross the line. Nowadays, though, and before I turn it over to him to talk about intellectual property, this isn't like the old days where everybody pretty much lived in their condo and you were like going door to door saying, I'm running for the board, or the board is doing this, or the board is doing that. We have so many people that own second or third homes, that they're investment properties, that they may live in other states or other countries. So going door to door may not be an effective means of communication because you may be talking to a lot of non-voting tenants or residents. So in the new age, before I turn it over to the intellectual property guy, it's more about communicating electronically.
And yeah, and that's where things get really pretty dicey here. So generally, right, first of all, there might be stuff in your condo deck that talks about what you can and cannot do there, and whether or not you're allowed to put flyers on there or not. So first of all, you gotta check the condo. Second of all, you gotta be truthful in what you say in whatever it is you're putting out there, right? Because here's the deal. To the extent that you have a right to freedom of speech, and we talked about kind of where there's some lines there, you've got a right to say whatever you want, but that doesn't mean that you are absolved of all liability that comes from whatever it is you said. If I, in a crowded theater, yell fire, I'm allowed to do that, but I might also get in trouble for it because I created some kind of disruption. Similar, just like I said, you can't pretend to be McDonald's when you're not. You can't go around posting flyers pretending to be somebody that you're not. You can't go around claiming that so-and-so endorses whatever when that's not true. You can't masquerade, it's called false affiliation. You cannot claim that there's some kind of affiliation between A and B when there is not. And you can't go out there and make false statements about other people, like, oh, so-and-so was caught, doing something illegal, improper, whatever it is. If you're going to do that, you better be right on that, right? And do not pretend to be somebody you're not. Do not pretend to be, any types of, like I said, false affiliation, false endorsement, false statements. All of that can get you in trouble. You're allowed to say it, but you are not absolved of whatever liability may come from doing that. So be careful. And again, those flyers may be prohibited by your condo desk. Check.
Right, isn't that true
That there's a nuisance or an anti-solicitation rule or a covenant? Could that happen? Do condo association attorneys ever send out letters to that effect?
As long as it's properly passed and uniformly enforced.
Okay.
Okay, next hypothetical. I want to create a Facebook page using the name of my condominium. They also have a great logo that will help identify the page. Can I do that? Who owns the name and logo anyway?
Sounds pretty good for sure.
All right. Yeah, the association is the entity that's going to own the name and the logo in almost every instance. Now, the interesting thing is they can be split, and that gets into some complicated stuff. But the name and the logo is almost always owned by the association because the rights to trademarks, which would be, the name, the logo, etc., are owned by whoever's using it to market or promote goods or services, as the case may be. So you have to have it tied, because the idea, right, the overarching principle is that when you see a trademark, you associate it as the consumer in your mind with the source, they call it the source identifier, of the goods or services being offered. When you see the McDonald's Golden Arches, you know it's a McDonald's. When you see the term Big Mac, you know that comes from McDonald's. And you have an expectation as the consumer of a certain quality, or depending on who you are, lack thereof, not saying anything about McDonald's, but it's different tastes for different people, as to what it is you're going to get. And so that's what a mark is, right? And so the question then, can you have that Facebook page? Well, the answer again is going to be, it depends. What are you doing with it? Because trademarks are only enforceable to the extent they're being used for commerce. There's something called fair use, which means I can say, I ate dinner at McDonald's tonight. It's not true, but theoretically, I ate dinner at McDonald's tonight. I'm not trying to sell McDonald's, I'm not trying to, masquerade as McDonald's, I'm not trying to dilute what's called dilute the McDonald's trademark, I'm just telling you a fact, right? And that's called fair use. I'm not trying to sell you anything, I'm not trying to disparage anything, I'm just stating the fact. And similarly, you could say, I live at, 123 Bayside Condo, whatever that name happens to be, that's a fact. Where you get in trouble is when you start trying to masquerade as being the association. If you're in a managed building, right, so a condo hotel or a condo that has a hotel or rental component to it, when you start putting your unit on Airbnb and you're claiming to be or masquerading as if you are the official rental program and you are not, that's where you're going to get into trouble, right? You're allowed to say, oh, I'm renting my unit at 123 Bayside Condo, if that's what the building is commonly referred to, or in the case of it being the street address, which is what you see a lot of the time. You can do that as long as you're not trying to pretend you're affiliated or you're somehow associated with the official management. Just Facebook pages. Again, don't pretend to be the condo board if you're not. That's where you're going to get into trouble. I'm seeing now condo developers, because of some of the issues with these, with daily rentals, they're starting to split the name and the address to make it harder for people to say, well, I'm just saying where it's located. Having one name for the building that is not the street address. So those are all things you need to be careful. But again, the key is just being the truthful purveyor out there. Don't pretend to be something you're not. That's when you're going to run into problems. And don't try selling anything under the name of the condo unless you're authorized to do so, unless the board said, go ahead and do this. Once you start looking like you're trying to purvey any kind of good or service, that's when you're going to start getting into some real potential for danger.
Took my next hypothetical, which was, I'm going to list my condo unit on Airbnb for the months I'll be out of town this summer. What should I know? So we know some of that. Anything else we want to know about listing on any of the vacation rental platforms? Or?
Sure. First of all, make sure that you can do that, because there's the law in that area is in flux, and you may be in a location that is not allowed to do that. I live on Miami Beach. Miami Beach had, what was it, $30,000 a day fine?
$20,000, but it's being
Used to
held
be.
up by a court opinion that's adverse to that.
Correct. And Miami Beach is very strange because there's a district of Miami Beach where rentals are expressly allowed, and then there's where I live on Miami Beach where it's not allowed, and who's the guy shop over there? That's on Miami. That's on the Miami side. Never mind. That would never happen. Now, Venetian Islands in Miami, there was a house that's notoriously rented out as a party place, and somebody actually got shot there the other day. I forget who else was partying there. Anyway.
Fortunately not in Miami.
Yes, I've heard. There's a line of those islands, right? We're talking about we're on the west side. Okay, other things you need to be aware of. So one, make sure it's legal. Two, make sure you comply with all applicable local rules, laws, and regulations. Some places require you to collect taxes. Some places require you to get special permission or register your unit. Some places require you to file certain paperwork. Make sure you do that. Also, make sure that you're complying with your condo decks. Does it say something in there that you're not allowed to do this because it violates these short-term rental provisions? Lots of condo declarations have those in there. And again, don't pretend to be something you're not. Don't promise something that the person will not receive. If there's some kind of restriction, if you're in a multi-unit property that has a rental element to it, and only the people with the official rental program get to use one of the two pools, don't claim that your Airbnb guest is going to get to use both pools. That's not true. That's where you're going to get into trouble. I represent the Satai on Miami Beach, and we've had a number of cases against people engaging in this behavior. And the issue with it is that when they pretend, it's a condo hotel, so it has an official hotel portion of the building. And the problem is when people go out there and they pretend that they are the hotel, and they're not, but they go and say, oh, you get all these things that are part of the hotel, even though that's not true. What happens? When somebody has an issue with it, they complain, they go on TripAdvisor, they go on Expedia, they go wherever, and they go, oh, no, this is nothing at all like what it said in the hotel website, blah, 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 blah. That's where the condo, because in the Satai's case, the Satai owns pretty much all the common elements of the building. That's where they're going to get really mad, because now you're starting to harm their reputation because you're pretending to be something you're not. So as you can see, there's a theme. Don't pretend to be something you're not.
Terrific. Okay.
By raise of hands, has anyone in this room ever received a letter from his or her association with the following phrase? Cease and desist. Govern yourself accordingly. How many? Wow.
I've gotten them for 30 years. And I've
That's a
gotten them for
very,
30 years.
that's a,
I've won.
so I would say that's almost 50% of the room, wow.